Good afternoon, everybody. This is Rob Solt, and we're here to talk about the workers' compensation hearing process, which now consists of telephones. I imagine most of you have been through this process and are well aware of the problems that it's created and where we stand. I think 1 year ago, if you had told me that we would be having a webinar today, a year later, in February of 2021, where we'd be talking about telephone hearings, I think I would have believed that about as much as if you told me you were going to sell me the Brooklyn Bridge. Originally, we said, and based on what we were told, that this would last a minimum of 3 weeks. Well, we're just short of a year now, so it's lasted quite a while, and it's going to last quite a bit longer from what we will talk about in a little bit. If you think about this, a year since this started, we've had 500,000 deaths in the United States from COVID-19, and that's just tragic. I heard a statistic the other day which just took my breath away, and that was that we've had more people die of COVID-19 than all the people that died in World War I, World War II, and Vietnam combined. Think about that. Now, I know people can argue that statistics can be manipulated and all that, but the bottom line is this has been an absolutely devastating event for our country. It's affected every facet of our lives, including our professional lives, if you deal with workers' compensation. When this started, the experts were saying that there was a question on whether a mask was a good thing to wear or not a good thing to wear. Now we have some experts that say you should wear 2 masks. When we started, there was no vaccines. Now we have 2, hopefully a third very close to being approved, and several others that are close also. We've learned about words like PPP loans and all the other things. Dr. Fauci has become a household name in our country. All these things have happened that we did not expect to occur. As I said, we thought this might be a 3-week situation. Well, it's turned into a year. And if you think about it, the workers' compensation system is like a petri dish. We have hearings across the state of Ohio. We have waiting rooms, multiple hearing rooms. And what we have then are people going in and out of these hearing rooms every day. Some are sick, some aren't sick, all of those things. So, that makes this a very difficult situation to deal with in general. Do that. There we go. It's a year later. What's going to happen? Will we go back to what we knew the world to be before 2020? Well, I will tell you, I've talked to many people, people from the commission, hearing administrators, lawyers, and the answer that we are given consistently by everyone is there is no clear policy or direction at this stage from the Industrial Commission. The Industrial Commission is going to do what Governor DeWine tells them to do, and Governor DeWine at this stage has not told them. There is no plan for a return. There are various rumors out there, but there is no specific plan that has been put out there to be utilized at this stage. How long that will be, some people say September, some people say the end of the year, but truly no one knows. And a lot of that will depend on the vaccinations, herd immunity, and all those things. Now, a good question is, will we ever return to what we knew prior to 2020? And I think the answer to that is probably no. I think it's pretty clear that a lot of people have concluded that many types of hearings can be done by phone. Whether you like the phone hearings or you don't like the phone hearings, the reality is things such as ADR, alternative dispute resolutions, C92s, and things along those lines can be done this way, and probably will. Now, why, when you ask the question? Well, if you think about it, it does substantially reduce cost for both the claimants and the employers. Attorneys can stay in their office versus driving to Lima, Mansfield, Logan, Columbus, Cincinnati, all the places that all of us have gone over the years. So the reality is, will we return to what we all knew as normal? Probably not. There will probably be modifications. There was a request to have some input with the Industrial Commission by a group out of Columbus at the beginning of this process, and that didn't go anywhere. So I really think that if you look at it fairly, the Commission's in a very difficult place, the practitioners are in a difficult place, and the country's in a difficult place. So we don't really know where all of this is going to go. Well, let's talk about the process and what we have now. As you may recall, when this started, they were scheduling 2 hearings per hour. Now we have 3 hearings per hour. And these involve all issues other than permanent partial disability hearings, for which we have up to 8 hearings in an hour. Now, logistically, this causes some significant problems. As those of you who take hearings know, when you call in, there are constant interruptions. There are quality problems with regard to hearing the call. Calls are dropped, either completely or partially. And with that many people involved, it's very difficult for people not to talk over each other. So that has become a problem. Some of the hearing officers are better than others when it comes to conducting a hearing. What is supposed to occur is they're supposed to take a roll call before any of us start talking. Some hearing officers do that, some don't. Some hearing officers have better reception than others. Same with the representatives. And then you also have unrepresented claimants who have never been through this process, and it creates many, many issues. What type of hearings are being addressed currently? As you can see, we've listed pretty much most of the hearings that are out there, and the only one of these hearings that I have not had personal experience of taking are permanent total disability hearings. Now, I'm not sure, I have not talked to anyone that has done a PTD hearing that's been contested, and I think this makes sense because permanent total disability, as you all know, is lifetime benefits. I think it's very important that when you are talking about lifetime benefits, the hearing officer and all parties should be able to see the claimant, observe the claimant, because oftentimes what a medical report says and what the appearance of the person are different things. So I think on permanent total disability hearings, that's something that really needs to be done in person. But presently, we are doing every type of hearing other than, I think, permanent total disability and VSSRs, which I'll talk about in a moment, as if we did before. It makes it very difficult to cross-examine a claimant. It also makes it difficult to read the room. Most of you know that when you're taking a hearing, one of the most important things that you can do is watch the hearing officers. Sometimes the hearing officer is saying, be quiet, say no more, and sometimes you could talk right over that. In a hearing such as this, that doesn't happen. The other thing that's happening, which is sort of an unintended consequence, is it used to be when you were at a hearing, a lot of things got worked out before the hearing. For example, most all of you have taken C92 hearings, and those would get settled. A lot of them, probably 60 to 70% of them. ADR issues, you would ask what you're really pursuing, and maybe you would agree to one, and they'd agree to dismiss the other. Same with additional conditions. What's happening now is there is not a lot of discussion before the hearing. People just call in, and the issues get addressed. Likewise, we're having a lot more of reconsideration hearings on permanent partial disability because, frankly, it doesn't cost anything to file a reconsideration, and the parties are doing that much more frequently than they did in the past. What types of hearings are not being addressed? Well, as I said, VSSRs, we've not had any VSSR that's actually going to hearing, and that's important. As you know, a VSSR is a penalty provision. They usually are very highly technical. Oftentimes, you're going to have multiple witnesses and experts testify as to whether the specific standard has been violated. So those, fortunately, have not been going forward, although there is push out there to have that happen. So I'm not sure what that will really end up being. Death claims, you would think the same logic would apply to them as permanent total disability claims. However, I have myself argued probably 5 or 6 death claims in the last year, and these involve primarily asbestos occupational disease claims, and a lot of them are medical based, but it also creates a problem because they're complex, and it's something, in my opinion, that should be done in person, because once again, a death claim results in benefits for the widow claimant, if granted, for life, unless she remarries, etc. So these are things that are creating major due process issues, but they are going forward. All right, practically, how do you do all of this? I mean, how do you do this? Well, it's really not too difficult to do. The Industrial Commission will send you a notice, and it'll have the call-in numbers. On that notice, it gives you the number to call and then a code. It also gives you a number if there are problems, if you can't get through, that you can call, and that's an important thing that we'll talk about here in a minute. You call in, and it's important to also remember is there's a prompt on whether you are initiating the call. You do not want to initiate the call, because if you do, you will have the wrath of the hearing officer and create major problems. You wait until the hearing officer initiates the call. What you should also do before the hearing is you need to upload a document that says your name on it, the claim number, what your name is, if you're the claims rep or the attorney assigned to the case, the contact phone number, and all that information. We've had many situations when people have not put this in, and it creates a major problem. Some hearing officers will just go forward. They shouldn't, but some will. The bottom line is this document should be placed in every claim that's set for hearing. And it's happening now probably with about 75–80% regularity, but that's something that you really should do. Okay, tips. What can you do to make this process work better? Well, the first thing is be on time. I can't tell you how many times we have situations where a lawyer or a claims rep or the claimant calls in late, and when they call in, we're in the middle of another claim. And this creates major confusion and disruption, and frankly, it's rude. This applies also to hearing officers. There are some hearing officers that don't start right at 9 o'clock. It's a 9 o'clock docket. They call in 5 or 10 minutes later. This creates a major concern, because then the lawyers and the claim reps all wonder, is something wrong? Do they need to call the number on the notice that says if there's a problem, call this number? Well, people need to be on time, much more than before when we were waiting out in the lobby and we knew the hearing officer was there. So it's important that you be prompt and on time. The next thing is, it's like a conference call. Do not talk over each other, and allow the hearing officer to take a roll call. This is critical. You need to allow them to find out who's there before you start talking. Some hearing officers are better at this than others, and some don't do it, and it's a free-for-all. And especially when you're having a permanent partial docket of 8 hearings, and you have potentially 16 lawyers and some claimants on the phone, it is a mess. So you need to let them take roll call and do their job to begin with. When you're not talking, when it's not your hearing, mute the speaker on your cell phone, stay off the line, allow the other people to talk, because as you know, we get feedback on these calls, a lot of other things. So please do that, and that will make the hearing officers happy. Some hearing officers recently anyway, are saying that if you're on a cell phone and if you're on a speakerphone or you're using a headset, they won't take the hearing until you get off. Now, I don't know if that's right or wrong, but I've had a couple say that to the group, and with unrepresented claimants and things, that can make a mess. As I said before, please upload your sheet with the names of who's going to be there. And if you're going to have witnesses at a hearing, if you're the employer or the claimant, put their names there and the cell phone numbers so it's out there for everyone to see. Like before, if you're going to have multiple witnesses, request additional time. You know, it's not just a matter of courtesy to the hearing officers, but it's also important when you have all of these witnesses and things that you have additional time, because if you don't, you back up all these other people that are on the call. You know, we're having hearing dockets for C92s at 4 o'clock. In fact, I'm lucky I have a 4 o'clock hearing on Friday. But the bottom line is, we've been told that Columbus says they no longer need the 4 o'clock docket, but apparently they have to issue some directive to the local offices, which hasn't happened yet, so we still have 4 o'clock dockets. The bottom line is, if you're going to have anything out of the ordinary, you need to request additional time. Okay, what are our concerns about all this? What are the problems with the process? Well, it is, as I mentioned before, very difficult to cross-examine a witness and look them in the eye and determine whether they're telling you the truth. Same way, it's also difficult for the claimant, because if you have a very credible claimant, sometimes that just doesn't come through. So it cuts both ways. I think in-person evaluation of people is important, and I've always thought that's one of the most important things you can do as a representative, is tell your client whether you think the person is credible or whether they have issues concerning truth. And you can sort of see that and learn that as you cross-examine people and talk to them. Do not talk over one another, and this is really difficult. And for all of you that are on conference calls and Skype and Teams and Zoom, you know this is hard. And the bottom line is, you don't know when someone is done talking. Some people talk faster, some people pause. It's very difficult. Sometimes claimants in particular don't understand the process, and some of the hearing officers don't control the room or the call, so that makes it very difficult. But you need to be very careful not to talk over other people, and I think in this situation, less is more. Pause and let other people talk before you jump in. You can use a court reporter. We've done this a couple times. I'm glad I'm not a court reporter, because this is a very difficult job, trying to identify the people and make a record on the phone. It's doable, but I think you need to make sure that you have a very competent court reporter, and also that you spend time with the court reporter beforehand and say, there's going to be 5 people on the call. This is what they're going to say. This is who they are. Things like that, because otherwise you're making a very difficult task almost impossible in this scenario. What about playing the video? You know, oftentimes you'll want to play a video at a hearing. I would suggest that in today's world, the simplest thing that you're doing is you're going to upload the video, then you're going to ask the hearing officer to watch it during the hearing. Frankly, most of the time now, when I have a video of a job or surveillance, I ask them to watch it. I don't ask us all to watch it together because sometimes the claimant doesn't have a monitor to look at it. Sometimes the attorney's calling in from a cell phone. They don't have the ability to do it. But you can definitely say, I'd like you to watch the video that was imaged on September 12th, 2020, depicting the job the claimant was performing and all that. It's still helpful, but you also need to make sure that everybody has a fair chance to do it, supply it to the other side. And I'd also suggest to you that getting these online is more difficult. You'll have to have it probably delivered to an office and talk to someone to get them uploaded. If you just mail it in, good luck with the mail today and good luck having it on. So when we have one, we've usually had someone take it over and made sure it got uploaded. So just something to keep in mind. What do you do if your call drops? And this happens, unfortunately, way too much. Well, the first thing I would suggest, if you just drop your call, call back in the same number, and you should get back in. If you can't get in, or the line is not there, then there is a number to call on each notice, and there are different numbers calling a local office, and they will contact the hearing officer and tell them that you're having a problem. I've had this occur 3 or 4 times in the last year. As far as allowing for recording of hearings, there is no law or provision that says you can do this. Frankly, you couldn't do it before when we were having in-person hearings as far as taking a tape recorder in unless all the parties consent. So typically, you can't just tape this on your phone to do. That would create major potential legal issues, and I would strongly suggest that you shouldn't do that. Suggestions. One of these is have your client or witnesses on the phone call and then just conference them in when you call in. I will tell you, some hearing officers now are not permitting that. We had a call last week where the hearing officer in question said, I'm not allowing that. They need to call in individually. So I understand that they believe it causes feedback, but it can also make it very difficult when you have unsophisticated clients or witnesses or things. There are people out there that you want to have on the line just so they can talk. So what I do now is I call them, talk to them, give them the number to call in, and have them on an individual line. I think it's easier to do it the other way, but you need to be careful because there are several hearing officers that will not allow it. That is not commission policy, but it is the policy of some of the hearing officers in this state. As with most things, you shouldn't let the other side lead a witness or present the testimony for them. This has always happened some in the agency, but I think especially in a scenario where you cannot evaluate the person's demeanor, I think you need to at least say, hey, wait a minute, we want to hear what Mr. Johnson has to say, not what attorney or union rep so-and-so has to say. And most of the hearing officers will support you on that if you do it professionally. I think this is important, whether you're a TPA or a law firm. There should be one attorney assigned to a room. You know, what's happening now is there'll be a notice put in, I'm also in room 3 and I'm in room 6. Well, that is rude to the other people that are on the call. You make the hearing officer wait, which is not a good thing to do in general. And it's also, you back up a whole room full of people that are waiting, especially on permanent partials where you have potentially 16 people on a phone call. You know, best case scenario with 3 hearings, you're going to have 7 people on a hearing and potentially more. So I think the cost part of this is you should be able to assign one attorney to one room in 90% of the cases. You know, it's not like we're now traveling to multiple cities. You're sitting in the same place in your office or wherever it may be making the call. So I don't think it's too much to ask. Obviously, there are sometimes you have scheduling conflicts, and that can affect all this, but it's not too much to do, and I think it's a matter of professional courtesy. As with before, you need to make sure things are uploaded, timely filed, and importantly, because this is becoming a major problem in this process, you need to send it to the opposing party. Just because you put it on icon doesn't mean you've complied with the rules. And that is a basis for a continuance if you need it. So please, please, please send it to opposing counsel. Also, the hearing officers, they're working remotely, and some are better than others at this, but you're going to be asked more often than not now is, where is the operative report? Where is the MRI? Where is that office note you just referred to? So you need to know where it was imaged or what date it was imaged, what it's called, and if it's page 3 of 19, wherever it is, and that will help you. You make the hearing officer's job easier. If you make their job easier, I think you have a better chance for success. Common sense, but it's something that is amazing how often it's not done. People just think they can go in and make a reference to it and expect the hearing officer to find it. Not a wise choice. I think most of you probably do this. Utilize your computer and icon during the presentation. What I typically do is I have 2 screens. I'll have icon up on one screen and then my notes up on the other screen. And that way, when someone says something and you need to find it quickly, or they're referencing a document that you maybe didn't anticipate, you can go to icon right then and there and look at it. Or if the hearing officer wants to know where the MRI is, you can find it and show it to them right away. The last thing is, there is due process in this system. And if you are not being able to make your presentation, if the phone quality is so poor that the argument's not being made, if there is insufficient time, I believe you should request for continuance to the table and explain your reason, and hopefully the hearing officer will give you some deference. I've had that happen a couple times. I've requested it once. I've had another party request it once, and part of it was there were technical problems, some other things. But the bottom line is, every party, the employer and the claimant and the lawyers, are entitled to due process and the ability to make their presentation. If that's not happening because of technology, you need to raise that issue. If the hearing officer says no, ask them to note your objection in the order and the basis for the reason, because you can raise that issue at the next hearing. All right, we're going to take a quick poll here if everybody's here. I'd like to get everybody's opinion on, do you like these hearings? Do you not like them? About the same or not applicable? So we'll take a minute here and take the poll quickly. As you can see, you'll text this to Bugby Lawyers as indicated on the screen. I'll also be glad to answer any questions, or if we'd like to have a discussion about what you personally think of the hearing process, what your personal experiences have been, and any suggestions that you believe that can be made to make this system better. I will tell you that they are apparently, the commission that is, looking at upgrading their phones and the phone process, because there have been a lot of problems with the system. And there's also some talk, although nothing official, that they may look at other ways to do this, such as Zoom, etc. But none of that has come to fruition at this point. Okay, it looks like on our poll, half of you like them and half of you don't. Well, that's probably about true with the way when you talk to people. I think the reality of all this is, and I'd be interested in anybody's thoughts, is that there is a place for telephone hearings on certain types of things. There's probably not a place for other types of hearings, as we've talked about. Question is, what will we end up with? The answer to that question is nobody really knows. Well, it looks like more of you are liking these as I'm talking, so that's interesting. 67% like them. It is convenient, but I'd ask the question, of those 67% of you that like them, what do you believe the quality of the calls are? If you can send a chat or a message. Is anybody here having calls that are perfect or calls that are awful? I've had both, and unfortunately, I'd say there's more technical difficulties than not in these cases. Well, it looks like it's changing now. People are changing their mind. It looks like most of you don't think they're effective, and I would agree with that. I think they are cost efficient. I think sometimes it's nice not to be driving to Mansfield when we've had a 12.5-inch snowfall, but are they as good? The answer is probably not. Well, with that, are there any questions or anything that people would like to talk about concerning the telephone hearings in Ohio? All right, well, I don't have any specific questions. I'd like to thank everyone for tuning in today. And I like to thank all of you that are participating in the process, because I think most people are doing a good job with it. I hope that we get more direction from the Industrial Commission in the near future as to where this is going. But I think, as I said before, we can all understand that it's very difficult. It's unbelievable where we are a year from now, and this awful pandemic has affected everyone, not just the Bureau of Workers' Compensation. Thank you very much, and everybody have a good day. And stay safe. Bye.